In the previous section, we discussed how marital status and mental capacity influence contract execution and enforceability in Arizona real estate transactions. We learned that contracts require competent, authorized, and consenting parties for validity. Building upon that understanding, this final section examines what happens when one of those parties passes away before a transaction is completed. Death is a natural event that introduces legal complexities into real estate contracts, as it affects the ability of a party to perform and raises questions about who, if anyone, can complete the transaction. In Arizona, the general rule is that a valid and fully executed purchase contract remains enforceable after the death of one of the parties, provided that the contract was binding at the time of death. A properly formed real estate purchase contract creates not only personal obligations, but also equitable interest in the property. When a seller signs a contract agreeing to sell real property, and a buyer accepts those terms, an equitable conversion occurs. Under this doctrine, the buyer becomes the equitable owner of the property, while the seller holds legal title in trust for the buyer until closing. Therefore, if the seller dies after signing, their estate must generally honor the contract. This principle is supported by Arizona case law and reflects a broader equitable doctrine applied nationwide. For instance, if a seller enters a binding contract to sell a parcel in Mesa and passes away before closing, the estate's executor or personal representative has the duty to carry out the sale according to the contract's terms. The buyer retains the right to specific performance, meaning they can compel the estate to complete the transfer of title. Likewise, if a buyer dies after signing a purchase contract, but before closing, the buyer's estate may still be obligated to proceed with the purchase, assuming sufficient funds are available and the contract remains enforceable. A buyer's death after contract acceptance does not automatically terminate the contract, but where no estate or heirs exist, the contract becomes unenforceable due to impossibility, and the seller's remedy is typically cancellation and return to market. However, if a party dies before a valid contract is formed, such as before offer and acceptance are complete, the death terminates the offer immediately. Under Arizona contract law, an offer is a personal invitation to enter an agreement and cannot survive the death of either party. For example, if a buyer submits an offer on a home in Scottsdale and dies before the seller accepts it, the offer becomes void upon death. The seller's later acceptance would have no effect, as there is no living party to form mutual assent. In cases where one party dies after a contract is formed but before performance, the determination of enforceability depends on whether the contract was personal in nature or property related. Personal service contracts, such as agreements relying on a party's unique skill or identity, are extinguished upon death since performance cannot be delegated. Real estate contracts, however, are not personal service contracts. They are property-based obligations that can generally be fulfilled by the deceased party's estate. A real-world illustration helps clarify the difference. Suppose a real estate investor agrees to sell a commercial property and signs all documents, but passes away before closing. Because the sale pertains to property, not personal service, the estate's executor has the legal authority to complete the transaction. Conversely, if the deceased had been contracted to design and build a custom home, the contract might terminate upon their death, because performance required personal expertise that cannot be replaced. The situation becomes more complex when the deceased party's heirs or beneficiaries dispute the contract. Under ARS, paragraph 14-3709, the personal representative of an estate has the power to fulfill enforceable contracts entered by the decedent. If the heirs disagree, their recourse is limited, as the estate must comply with legally binding obligations. Similarly, under ARS, paragraph 33-431, the conveyance of real property through a decedent's estate requires compliance with probate procedures, but the underlying contract remains enforceable unless fraud, undue influence, or incapacity can be proven. It is also important to note that earnest money, deposits, and other funds tied to a pending transaction are handled according to the contract and estate laws. If the buyer dies before closing, the earnest money is typically refunded unless the contract states otherwise. If the seller dies after accepting an offer, the funds are held until the executor executes the deed. Escrow companies and title agencies play a crucial role in managing these funds and ensuring compliance with probate court requirements. Brokers and licensees must navigate such situations with sensitivity and diligence. Under Commissioner's Rule R428-101A, real estate professionals are required to protect the interests of their clients and ensure lawful handling of all documents and funds. When a party dies before closing, the broker must immediately notify all parties involved, including escrow and title, and verify whether an executor or personal representative has been appointed. Continuing to process a transaction without confirming the estate's authority could expose the broker to liability for unauthorized actions. Discussion: what happens to a real estate purchase contract if one of the parties dies after signing but before closing? Answer: the contract typically remains enforceable, and the deceased party's estate or personal representative is obligated to complete the transaction according to its terms. Why does an offer to purchase property become void upon the death of either party before acceptance? Answer: because the offer is considered a personal proposal that requires living parties to establish mutual assent, and death terminates the power of acceptance. How should a real estate professional respond if a client dies before closing on a property? Answer: the agent must immediately notify all parties, pause the transaction, and confirm the appointment of a legal representative authorized to act on behalf of the deceased's estate before proceeding. Review summary: the death of a party affects a real estate contract, depending on when it occurs in the transaction timeline. If a valid contract exists before death, it remains enforceable, and the estate is legally bound to complete performance. This stems from the doctrine of equitable conversion, which treats the buyer as the equitable owner once a binding contract is signed. However, if death occurs before acceptance, the offer terminates automatically, preventing mutual assent. Real estate contracts, being property-based rather than personal in nature, generally survive death, though probate processes govern the execution of deeds and distribution of proceeds. Brokers must act prudently by verifying the authority of estate representatives and ensuring full compliance with probate and recording laws. In all cases, the core principles of contract law, mutual consent, capacity, and lawful authority continue to guide enforceability even after death.